All right.
Please be seated. All right, let's go ahead and call the record. This is Nehemiah versus James for last year. Nez County case number CR35-21-0815. Mr. Brashear is present at council table with his attorney, Mr. Bundy, and Mr. Coleman, Ms. Smith are present on behalf of the state. Council, is there anything we need to take up before we return to this one?
This time we're ready.
No, you're, all right, let's go ahead and look forward to the record. All right, can you be seated? Good morning, ladies and gentlemen. When we wrote the bidding yesterday, Mr. Bucky and Mr. Brashear are in the process of presenting evidence. And Mr. Bucky, I'll allow you to call your next witness. Gladys Brewer. If you would please proceed. On close. Good. Please state and spell your name correctly.
It's Gladys Brewer, B-R-E-W-E-R.
Thank you. Spell your name.
I'm a supervisor at the Department of Health and Welfare, Family and Children's Services,
How long have you been as an employee there?
about years.
Please talk about your education, training, and experience that you qualified for that position.
So I have my bachelor's in social work, and I have my master's in social work, and I'm a licensed master of social work.
Have you ever met my client who's seeking last student in big time?
I have,
This is a person meeting with James Brashear.
that is
How many opportunities have you had to meet with Mr. Brashear?
just once.
And was that one time on February 5, 2021?
I believe so, yes,
When you met my client, did he have anybody with him? Do you
He did.
remember?
he did.
Who was it that you understood was with him on that day?
His daughter, Rebecca, Mast.
Do you recall about what time of day it was that you met with my client and Mr. Brashear?
I'm not exactly sure of the time. I do know it was before school was let out. I'm thinking roughly around 1 o'clock.
Okay, sometime that afternoon.
That is correct.
Do you recall the circumstances in which you met with them?
Yes.
Describe that to the jury.
Yes. Mr. Revere and daughter came in seeking some help from the department.
And protecting grandchildren.
That is correct.
It was Mr. Brashear's grandchildren, yeah.
That is correct.
And Miss Brashear's children.
That is,
And you met with them.
yes.
For what period of time did you call me?
It was probably a good 30 minutes.
Where did you greet?
I originally created the mountain lobby of our office, of our department there.
Did your meeting would then move to a different part of the office?
It,
Okay, will you talk to me or jury about what you told about Mr. Brashear, the leader, when you met him outside in front of the office?
so when he arrived at the department, he appeared very calm. He, spoke, well, I mean, slow. I mean, there was no, anxiousness or um, really the department, the help. Mr. Frazier did become emotional. His eyes were welling up with tears, and he had some tears coming down, as well as he was like shaking a little bit.
When you say he's shaking, what part of his body did you see shaking?
Just when you're scared that maybe something happened, just your whole body kind of shakes just a little bit. It wasn't like you know overwhelming, but it was enough for me to notice.
About Mr. Brashear, you notice any change in her demeanor when we first met her until after
She was a little more again. He was more common than she was a little. I don't. I think escalated is, but it's escalating. You have to move forward and have her like it's okay type of thing. But she was clearly a little bit escalated. A little, not angry, not angry, just fearful.
All right, that's all I have.
Mr. Prosecutor.
After they left your office that day, did you see the defendant ever?
No, I didn't.
Mr. Any regret? Thank you. May this witness be seated.
Yes.
Thank you. You may step down. Mr.
Now, as you indicated previously, I do mention we need to take that possibility.
Thank you. Ladies and gentlemen, we'll take a very short recess. And again, as I indicated before, you'll hear it one more time now during the course.
We are that Mr. Brashear inspires testify about why he was so emotional and his state of mind was affected to the degree that witnesses had to some degree testify. We have heard in the course of this day on February 5, 2021. As the court is aware, my client was aware of ongoing investigation involving child abuse of his grandchildren. That was something we knew about. There were local law enforcement authorities here who actually testified by way of Zoom proceedings in North Dakota to protect Mr. Bashir's children, saw those hearings that contributed to his grandchildren being sexually abused. You saw testimony yesterday from Christy Chase, who testified that he had worked with these children for 2 to 3 years. She was prepared with him testifying that he has heard directly from those children during their work with her that they were so abused. That is shared with my client and with the family in general, and that certainly would have contributed to my client's state of mind on this day when he believed that the children were going to be potentially susceptible to vulnerable to such abuse again over unsupervised visit during that weekend, February 6th through February 8th. We have, the defense, done our best to look within the court's order and limit the testimony not only witnesses who are on the stand, like Ms. Chase, like Becky Shear, of course, also did direct evidence she could have offered from children's court, and from Robert Bashir, the grandmother of these children. More importantly, for motion about to be, Mr. Bashir's testimony has been significantly limited by way of the court's order, which included reference to what caused the state of mind on his defense. I would particularly reference the screaming and crying of Bashir grandchildren when my client was in the apartment. My client knew and understood what that screaming and crying and pleading was about. It had dramatic effect on his state of mind, and the order dramatically affected his ability to communicate to the jury what his state of mind was pretty much during this entire day. He would have preferred to tell the jury that he feared such outrageous action were possible and how it affected him, but he wasn't able to do that. I will note record that at one point during Mr. Bashir's testimony, he was talking about that conclusion. When the children cried out and screamed, he began to say that they needed him for help, and the state objected. I didn't have to tell you, I understand the state has a right to object. At the same time, that was a moment of Mr. Bashir's case where he had an opportunity to talk about how he was affected at a short period of time prior to going to this Rose parking lot and what it meant. We had to take a break from his testimony at that point, which disrupted his testimony for a significant period of time. I can only estimate it took at least 15 minutes, perhaps more, before he could get back on the stand and to protect the court's order. I asked a leading question as opposed to letting Mr. Bashir offer the testimony himself. I have agreed to put on a case to bring this motion because I've been going to make a motion for in this trial, is in my opinion, after trying to constraints of what the court previously ordered, it is now my professional opinion that Mr. Bashir's case has been significantly compromised. In particular, his ability to tell his own story. I would cite, this is all for the record, for possible appeal. Your Honor, once the court is one, I made this motion before we take our case. In case the court is willing to allow us to reopen, in which case I can cure what we feel has been a violation of my client's rights. So I would offer that as an alternative to my motion. And I would cite Rock versus Arkansas 483 U.S. 44. It's a 1987 case. It's a crucial case at a federal level that pretty much indicates that a criminal defendant's right to testify is a fundamental right. Yet how defendants have the right to testify in their own behalf under the due process clause of the 14th Amendment, the compulsory process clause of the 6th Amendment, and the 5th Amendment privilege against self-incrimination. Further held, although the right to present relevant testimony is not without limitation, restricting these placed on a defendant's constitutional right to testify by a state's evidentiary rule may not be arbitrary and disproportionate to the purposes they are designed to serve. I understood part of the ruling to be that this circumstance suggests an allegation, however it may be phrased, of child abuse, particularly child sexual abuse, criminal the trial caught the attention of a jury, might be such an overpowered suggestion that it would affect jurors' emotions so that they would not engage in all of the corrections, listen to evidence, all. But Your Honor, those powerful possibilities that a jury might be so affected are exactly the sort of things that affect my client. They are. And without an opportunity to have testified about that and how powerfully effective his statement was, knowing those things, particularly back to the grandchildren, what he knew was happening to them moving forward. It had compromised his ability to show his mind as the approach was commenced. We had basically argued or presented evidence back where my client testified only his careful mistake. He couldn't be watched. His jury would be left to speculate about why my client was fearful for Satan grandchildren. They're going to be left to speculate whether he had a good basis for it or whether he's making it up as an aid or some possible lesser crime. There's a real basis that most people of authority in the courtroom know like a real basis to have that with the jury. And again, that compromises his ability to defend himself. And so for all of those reasons, I ask either we can reopen our case and cure these problems, or we ask for this trial. I've tried to bring this up so we can have it settled to the Idaho State Supreme Court. Before we got to this point, they declined it. They said, try the case first. We've now done that. My position remains the same as even more so now, having seen how the evidence has come in and what evidence has not.
Well, Mr. Bishop, or Mr. Bugby, can you point to any authority to support the proposition that any abuse by John Mast is an essential element on the first degree murder or its defense?
So we have offered volunteer manslaughter instruction as a lesser included. Part of that instruction reads there is no else thought if the defendant actually adequate provocation while in the heat of passion or excitement quarrel, even if the defendant intended to kill the deceased. Provocation would have been adequate if it would have caused a reasonable person in the same circumstance to lose self-control and act on impulse without reflection.
My question is, where's the authority to suggest that it's an essential element?
Well, the essential element is balance profile in reference to first degree and second degree murder. In reference to first degree murder, it also goes to the ability to meditate, weigh consequences, and make a plan to carry out murder. And then, as I've indicated, in reference to the first or voluntary manslaughter statute, that frankly is argued, Your Honor, that the client was in such a heat of passion following his emotions. He felt anger, he felt fear, he felt dismay, he felt failure. All of these things contributed to an impulsive. Reflection. He testified about what happened after hearing those statements from Zane. He said he snapped. I will tell you as an offer of proof that Detective Crane, if asked, but I couldn't ask him, Detective Crane would have told the jury that during the course of his interview with my client told him at that moment he snapped as well. And then I testified that he did have changed the frame of mind, and when he left that apartment, he was upset and was planning to go home, but somehow ended up going towards those hours. He was so affected that he had to stop and attempt to compose himself. By the time he gets to those hours, he doesn't even recall how the gun got into his hand. He doesn't recall the shooting until Miss Troyer snapped him out of some state of mind he was in, where he realized he had the gun and he knew what. So all of these things either negate an essential element of first or second degree murder and help at least give the suggestion that this may have been a voluntary manslaughter. These are this testimony we seek to offer is relevant to this profession. Ms. Smith or Mr. Cole, would you like to respond?
Thank you, Your Honor. Yes, Your Honor, the state requests the court deny the motion for mistrial and not allow the defense to reopen its case. The state stands by its briefing related to the motion to file, which resulted in the court's order not allowing this information in. The information is not relevant. It's improper character evidence. Its prejudicial effect outweighs the probative value of this evidence, and ultimately we end up with a trial within a trial about whether John Mast committed these acts or not. That is not why we are here today. We are here today to determine whether or not the defendant is guilty of first-degree murder. And it makes the jury lose focus on exactly why we are here. It is true that the defendant does have a right to testify, but he does not have a right to testify about anything he wants to. And the rules of evidence always apply to the defendant, just like they do everyone else. There is not unlimited testimony the defendant can provide. And so based upon that, Your Honor, the state requests the court.
Thank you very much. Mr. Buckley, thank you for your articulate argument. I appreciate where you're coming from. I don't know that I've heard anything that is changing my position. Again, I guess for sake of time, I'll just refer you to the reasons I articulated in my order that was filed on October 18, 2022. I share the state's concerns. I recognize that the defense and the defendant has an opportunity, his right to protect the defense or to present a defense is protected by the Sixth Amendment. I understand that. Again, as I indicated in my order, that right must be balanced against any interest the state has in a criminal trial process. The Sixth Amendment does not confer the right to present testimony free from the legitimate demands of the adversarial system. And in the case law, nor is a defendant free to present a defense based on relevant evidence. We went through those. I'm going to stand on my October 18, 2022 order. Just noted your objection for the record. I'll accept your offer of proof as you have articulated it. I'm going to respectfully deny your motion for a mistrial. Just going to deny your motion for mistrial and we'll move forward.
We will be prepared to rest.
Thank you very much. Sounds to me like when the jury comes back, Mr. Bugby and Mr. Brasher are going to rest their case. Does the state anticipate witness?
Yes, Your Honor, the state has 1 minute.
Is the state ready to go in the event so we don't have to take another break? And I expect that you may have some sort of a
Yes, I need to make sure that witness.
All right, so it sounds to me like we will go. All right. If there's nothing further, we will go ahead and return the jury. Ladies and gentlemen. Mr. Bunting. Thank you very much. Mr. Coleman, the state have any witnesses in rebuttal which you'd like to present?
Yes, Your Honor, the state calls Officer Tyler Crane.
Thank you very much. Please, sir. Sir, you make yourself comfortable and if you'll pull out close and if you'll state and spell your name for the record.
Crane, Crane.
Thank you. Ms. Smith, you may.
Your Honor. Yesterday, during your testimony on cross-examination, Mr. Buckby asked you about whether you were able to access the defendant's cell phone.
Yes,
And you testified that you obtained a warrant for the defendant's cell phone.
that's correct.
And pursuant to that warrant, were you able to review the contents of defendant's phone?
Yes,
And does that include calls and text messages?
that's correct.
Can you describe the number of phone calls that occurred between the defendant's phone and Robin Brashear's phone prior to the shooting?
Yeah, on the day of February 5th, I believe there was about 8 phone calls total. But most of those calls, I think all but 2 or 3 were the call duration I didn't feel was long enough to even have a conversation. And I know that cell phone service can be not super consistent, out in Lapway if that's where Robin was. Certainly up by Winchester and the area between. So there were several phone calls that were, a 6-second duration over 0 seconds, like the call never even connected. But I think there was 8 total.
And so you mentioned that your review of the records indicated that there were 2 to 3 phone calls that actually connected where it appeared there was a conversation.
Yes. And
And when did that first phone call occur?
I think it was, if I remember correctly, around 5:13 or shortly after 5 p.m.
And approximately how long was that phone call?
Trying to remember, there was a call at 5:13 and I think it was 5:21, just a short time later. One of them I think was just shy of 50 seconds, 49 or 50 seconds, and then the other one was just over a minute, 1 minute and 8 seconds, I want to say, or really close.
How were the defendant's phone and Robin's phone primarily communicating that day?
There were more text messages than the phone calls, certainly than the phone calls that connected.
After the shooting occurred, what is the first way the defendant's phone communicated with Robin's phone?
Mr. Brashear texted Robin, and the text said, "It's done."
And after that text message it's done, what is the next way there was communication?
Robin called Jim And I believe the duration of that phone call was 41 seconds.
Now, during your review of the text messages, were you able to determine whether there was a plan about Robin leaving work?
Yes, right around 3 o'clock in the afternoon, I think Jim texted Robin saying that Stephen, presumably Stephen Brashear, could pick Robin up from work in Lapway, and that Jim wouldn't be picking her up. And Robin acknowledged that text message and responded to it saying, I mean, it was shortly after 3 p.m., I think, and she texted saying that Stephen had just texted her and telling Jim to just worry about Becky and the kids.
So Robin was going to be picked up from work by Stephen, not from the defendant.
Correct, and the text message acknowledged that.
During your review of the text messages located on the defendant's phone, did you also locate a text message about the custody order?
I did.
I did have the witness handed what's been marked as State's Exhibit 36. Do you recognize what's been handed to you as State's Exhibit 36?
I do.
And how do you recognize that?
That is a portion of the Cellbrite report from the download of Mr. Brashear's cell phone.
And is this a true and accurate depiction of the text message exchange regarding the custody order?
Yes, it is.
State moves for the omission of State's Exhibit 36.
Mr. Exhibit 36 will be.
And who is this text message conversation between?
It's between Jim and Becky.
And can you describe what the text message is?
Yes, so the previous night, so February 4th of 2021 at 8:49 p.m., Jim texted Becky and said, "Did you say the original document said John would pick them up at 6 tomorrow?" And then just about 5 minutes later, Becky responded yes.
And so based upon this text message, it appears that the defendant knew the exchange was going to happen the day before the shooting.
I'll sustain that.
I have no further questions.
Cross-examination. Officer Green, you said no. Thank you. Thank you.
The state does not have any further witnesses.
Mr. Buckley, does the defendant have any witnesses in Surabaya?
Yes, we're gonna need the exhibit.
Make yourself comfortable. You'll pull that microphone close. I'll have you state and spell your name again for the record.
My name is REBECCA-BRASHEAR-MAST, Rebecca Brashear-Mast.
Thank you. Ms. Buckley,
For sure, I'm gonna refer to you again as just to make it support. You should have exhibit number 36 there with you. Do you see that?
I do.
You take a moment, just kind of read through there, just acclimate yourself.
Sure, and I can read it. Did you say the original document said John would pick them up at 6 tomorrow? And then it says yes.
That's a text message that you received on your phone from your father.
That is correct.
This would have.
I believe so.
according to the information on the data, almost close to, is that the recollection?
As far as I can remember, possibly.
Well, there's an indication that there's a document that suggests well, very specific. An original document that John will pick them up at 6 p.m. tomorrow.
Yes,
You know what is referred to when there's an indication of an original document?
yes.
What is it?
It is that John, a lot of times would say that he was going to pick up the kids and,
Your Honor, as to hearsay.
okay, sorry, I
Sustain
apologize.
that objection.
I will rephrase.
Asking about document. You understand the data before you go.
Yes,
So did you know if there was a document consistent with what he was asking you?
yes.
What document?
Visitation,
Around that time, now, he hadn't seen the kids in about,
6 months.
and we talked about this in your direct examination the other day.
That is correct.
But we talked about the fact that he might want to have some supervised visits, correct?
Yes,
Okay, and is this what you thought, so when you understood this text message you were referring to?
yes.
So again, I asked you this the other day too, I'll ask it again, did you have any idea that any soon to be occurring visits between John Mast and the kids would be unsupervised?
No, I had been emailed originally by the visitation
Hold
center.
on a second, Ms. Brashear, there's an objection.
Hearsay. She's talking about it.
If she's gonna talk about an email and the contents of the email, that is hearsay, and that's gonna be sustained. I will,
You received an email?
Yes,
Who is this email from referring to without telling us what's inside?
family dynamics. The visitation center in Clarkston, Washington.
Is this where supervised visits occur?
Yes,
As of February 4th, that's when this text message was sent from dad to her, right?
yes,
As of February 4th, do you have any expectation that there would be any unsupervised visits anytime soon between Mr. Mast and his boys?
no,
Does this email cause you any concern about the testimony you've given during the course of this case?
no.
Hesitate, why do you hesitate?
Can you rephrase that again?
The implication that the state's trying to make is you, the Brashear family, yourself, and your dad, knew that this unsupervised visit was supposed to occur on February 5 at 6 o'clock, as early as almost 9 o'clock. Is that true?
No, that is not true at all.
hold on a second, so here, subject. Ms. Smith.
The text message says, your dad asks you about John picking the kids up. Isn't that true?
Yes,
And the original document your dad is referring to is the order you received from the North Dakota judge on December 16th of 2020. Isn't that true?
no,
The order, are you familiar with the order from December 16th?
yes,
And in that order, the judge orders that beginning the first weekend of February 2021, John Mast shall have parenting time every other weekend, beginning Friday at 6 p.m. Do you recall that is what that order said?
yes.
I don't have any further questions.
You redirect, Mr. Webb.
They'll let you know.
Thank you.
So was this an ongoing issue?
Yes,
So that wasn't, in your mind, decided definitively as of February 2021. 21. Is that true?
No, it's not.
In fact, isn't that why you got a phone call from your lawyer in North Dakota the next day over your meal?
Yes,
Because there was an ongoing attempt that the visits not occur. Is that right?
that is correct.
Was your expectation is that they were not?
My,
I'll be more specific. On an unsupervised basis.
absolutely.
Hold on, Mr. Chair.
Sorry.
Mr. Chair, you may step down.
Thank you.
All right. Mr. Chair, I'll have you sit down again. Get comfortable. And I'll have you state and spell your name for the record one more time.
My name is Robin Brashear, Brashear.
Thank you. Mr. Bugby, you may inquire.
Ms. Brashear, thank you for being back again today. Did you have an opportunity to hear Detective Crane?
Yes, I did.
So Detective Crane indicates that there were, according to cell phone records between your phone and your husband's phone, there were approximately 8 phone calls that appear to have either been made or attempted to be made. Does that seem correct to you?
That's highly possible.
Okay. He, from reviewing the records, suggests that only 2 or 3 of those calls were connected. Is that correct? How many times you actually spoke with Jim Brashear on your telephone that day?
It feels like there were more, maybe, 4 to 5, like I stated yesterday, but they were very brief calls.
He indicated that the first call that he thinks connected would have been after 5 o'clock that evening.
No, I had spoken to him before that, and it may have been on Becky's phone. It may have been, another phone that was available. But yeah, I spoke to him more often than that.
All right. In fact, you were aware of the attempts that were being made
Yes,
to get this protective order, right?
yes, from the very, from the period of time immediately after they learned.
So let me talk to you about the potential calls around 5 to 5:20 or so. Right? You testified about a call where in the background you could hear your grandchildren screaming and crying. The detective indicates that 2 of the calls that he believes went through occurred at 5:13 p.m. Do you know if that would have been the call that you heard crying and screaming?
It seems possible that's time frame.
And then about 8 minutes later, there was another call at 5:21 that he believes went through. Did you have a phone call with your husband after you heard the crying and screaming, but before he got into those hours? Do you recall?
It could have been. It could have been.
It's at least possible.
Yes.
And do you have a specific recollection of receiving an actual phone call? I'm sorry, I'll rephrase. Did you have an actual phone call with your husband after the shooting occurred?
Immediately after, yes.
Now, I want to back up. The detective just talked about text messages that went between you and your husband.
Yes.
One of which, indicated desire that you call husband. You recall receiving that? Text message.
Oh, like I said, all of that period of time was very traumatized and very, very disjointed in my memory.
Let me ask you about this one. Do you recall the text message from your husband that said it's done?
I didn't recall that as a text message, but I do recall, in my mind, I was thinking stated that, but apparently it was a text message.
Okay.
And then my immediate response was to get hold of him. And that may have been a call from me to him.
All right, and then,
Okay,
Shira,
yes.
my recollection is, and I want you to correct me if it's wrong, but my recollection is that when you testified earlier in this trial, you indicated you got a text message from your husband that you didn't understand. Do you recall what the text message was?
It's probably the it's done, because I remember the conversation I had with him immediately to ask about that.
You think that's the text message that prompted you to call him?
Yes, absolutely.
And then you had a conversation where you found out what happened.
Yes,
You instructed him about how hopefully to keep him and others safe.
yes,
And that phone call ended at that time.
yes.
And that was the last time you talked to your husband on that 45.
There was a call from the police department later.
Okay,
That's,
give me just one more moment, please. I don't think I have any other questions.
Thank you. Hold on, this is cross-examination.
No question.
Thank you, Ms. Bashir. Can I step down? Mr. Bugby.
Nothing further to know.
Ladies and gentlemen, that concludes the evidentiary portion of this case. What I need to do now is take a break and meet with the attorneys. When we come back, we will be prepared to give you the jury instructions, and then following the jury instructions, what I'm going to allow each of the parties to do is to present their closing arguments to you. So we'll take our morning recess right now. I think this is going to take about a half hour, so I want you to be aware it's going to be a little bit longer than ordinary, so that I can meet with them and also I can copies to give to you. So I'll need a little bit of time to do that. So you recall that I did tell you that I would give you a heads up when it come time for you to start deliberating. You may want to make some plans accordingly in terms of securing phones, unless you would like us to hold on to those for you. Again, I expect that you will be coming back and having instructions and argument probably. Okay, so with that, I'm going to excuse you. I'm going to read this. During the course of this trial, you are instructed that you're not to discuss this case among yourselves or with anyone else, including any use of email, text messaging, tweeting, blogging, electronic bulletin boards, or any other form of communication, electronic or otherwise. Do not conduct any personal investigation or look up any information from any source, including the internet. Do not form an opinion as to the merits of the case until after the case has been submitted to you for your determination. And we're going to shoot for 10:30, so that's about 35 minutes, just so that you make whatever arrangements that you feel are necessary. So please rise for the jury. We'll be in recess.